Hey, good afternoon, everybody, and welcome to another one of our webinars here. Today, we're going to go through kind of a hot topic on a lot of people's minds as things get closer and closer to some of the key dates here that are coming up this year. But I think, as a lot of people know, all of these things with CMMC and the rollout, it's like already started. It's already been in the process a lot. A lot of subcontracts are requiring it. A lot of prime contracts are already requiring it. And so I think folks that are thinking that it's not going to kick off until November, or maybe even they don't have to worry about it for a year from November or 2 years from November, depending what they're thinking. It's one of those issues that I think is going to keep coming up. And as we're going to hear from Tom in a little bit, there aren't that many firms out there that are capable of getting you certified or making sure the certifications are up to date. And there's a lot of people that need to get there. So there's also a lot of time that you need to take into account there as well. So my name is Alba. I'm a partner at the law firm of PilieroMazza, and kind of been doing all things government contracts related for over 20 years now, and been working with all kinds of different government contracting entities and commercial companies that want to get into the space. And so we're kind of hosting our friends here from Forvis, who are excellent, not just accountants but also advisors in the GovCon space. And like I was saying, Tom here does a lot of the CMMC certification issues and making sure people are compliant. So I don't know, Tom, you want to give a little bit about you and about how Forvis can help people out?
Sure, absolutely. I appreciate the opportunity to join you today, Cy, and to speak with everybody. Again, I'm Tom Tollerton. I'm a principal or partner in Forvis Mazars. We are a top 10 public accounting and professional services firm globally via our Forvis Mazars network. But also, more relevant here, one of the early authorized C3PAOs. So we were actually the sixth originally authorized C3PAO back in 2022, and then reauthorized last year when the 32 CFR rule formalized the CMMC program for for the defense industrial base. We've worked with Fortune 500 primes all the way down to small businesses and virtually all industries over that period, and we've been working with NIST 800-171 really since the original DFARS rule came out in 2017. So tremendous amount of experience in our team, and I'm proud to lead that practice here for our firm. I also sit on the C3PO Advisory Council for the CyberAB, which is the accreditation body, the no-cost contract third party that manages the CMMC ecosystem on behalf of DoD. And so working with the CyberAB, working with C3PAOs to try and establish really consistent approaches, methodologies, interpretations around key questions related to the implementation of CMMC. So happy to kind of talk about that here as well today. But again, appreciate the opportunity, Cy.
Yeah, and so we deal with PilieroMazza, obviously deal with a lot of the legal issues. And I think as things get further and further down the road with some of these things, we've already dealt with certain false claim issues and things like that surrounding cybersecurity and CMMC issues. But Tom and his team are really, if you're looking to get certified and make sure you're ready to go, it's his team that are the guys that I would recommend that you work with. So I think we're going to talk through a lot of where we are right now, what some of the requirements are, what some of the level 2 processes are, because I think that's going to be the sweet spot, especially for some of the small businesses as you grow or quote unquote graduate and you're looking to get larger contracts or work with more sophisticated prime contractors. That's where things are headed. And then what happens after that? It's not just like a one and done issue either. So I think Tom can walk through some of that stuff as well. And then before we get started, I also want to note that the SBA's Office of Advocacy, they are looking for input. And I've spoken with them a couple times. I'm going to talk to them tomorrow, and then I'm meeting with a few folks on Friday as well to talk through how we're going to package certain requests or comments and get back to the SBA's Office of Advocacy so that they can communicate to not just SBA, but DoD as well, or DOW, about exactly what tweaks they think might be made or what would be good for small businesses as far as additional guidance. So to the extent that you have any questions or concerns or things you want to raise directly with SBA, just please let me know. Again, my information is going to be at the end, at the beginning too, but it'd be great if I could get some input there from folks that are listening along, and I'll pass that through and talk with SBA about it. So without further ado, Tom, why don't you kind of kick us off here with some of the current status and where things are going?
Absolutely. Yeah, and I don't want to dwell too long on kind of the very basics of CMMC, what it is. Hopefully most folks know, but it is always helpful to just kind of have a quick review before we get into kind of where we're at with CMMC. But obviously the Cybersecurity Maturity Model Certification Program is the program in DOW now for managing protections for controlled unclassified information within their supply chain, the defense industrial base. And so if you have a prime or a subcontract and you handle FCI, federal contract information, or CUI, controlled unclassified information, you will need to have the requisite level of compliance with the CMMC program. And there are different levels to that. And I think that's our next slide, which we'll get to in just a second. But the CMMC Project Management Office inside of DOW manages the CMMC program. As I mentioned, the ecosystem for assessors, official consultants, and assessment organizations is managed through a no-cost contract with the Cyber AB, or the CMMC Accreditation Body, Inc. And so that's who I deal with mostly when it comes to our work. But the CMMC program is comprised of three levels. It's called CMMC 2.0. And essentially, level 1 is foundational. So the very basic requirements, safeguarding requirements around federal contract information. And really, if you have any contract, the contract itself could potentially be FCI. So virtually every contract will need to comply with level 1. And there's a way to do that within the Supplier Performance Risk System, where you essentially have to self-attest or self-assess and then click the affirmation button inside of SPRS to meet that compliance obligation once it's in a solicitation for which you want to be awarded and hopefully win. Level 2 is where we start to talk about the third-party assessments. And the majority of level 2 compliant or organizations that need to be level 2 compliant will need a third-party assessment with a firm like ours, what are called CMMC third-party assessment organizations, or C3PAOs. And as Cy alluded to, there are a limited number of those. I think there are around 100 right now, which is still, as we'll look here in just a second, still there's going to be a bottleneck with that number of assessment organizations, even a couple hundred more. So again, as Cy was alluding to at the top, now is really the time to be getting ready, to be paying attention to this if you think this is coming down the pike. Level 3 is another framework on top of level 2 called NIST 800-172. It's expected to be far more limited than levels 1 or 2, just likely potentially a couple thousand companies, if that, within the supply chain. And then DOW themselves, through their DCMA arm, will conduct those assessments. So you'll need a C3PAO assessment for level 2, and then you'll need a level 3 assessment if that's included in the solicitation for your contract. And I want to highlight that real quick as far as what the expectations are. There's a lot of confusion on, do we need an assessment? What level are we going to need to be? It's going to be outlined. It needs to be outlined within the solicitation and within your contract. So it is DOW's responsibility for defining that. And it's your obligation to go get compliant if you're going to be awarded to that requisite level. So I don't know if you've got any additional comment, but that's pretty much it.
I did, in my discussions with SBA last week, their thought was that really level 2 is going to be where even like small businesses, I know there's been some confusion or maybe even miscommunication or false communications about how, oh, small businesses, you're just going to need level 1, you're just going to do your own thing. That's actually not what is anticipated. And for right now, right, this is a DoD, DOW issue, but it's going to likely get rolled out to various other civilian agencies. That's also very much almost a guarantee based on my discussions with various agencies and with SBA itself. And so they're really seeing this like level 2 as where everyone's going to have to be sitting in practical terms. So just be aware of that as well, that even SBA believes that that is going to be the case here.
Yeah, and I'll amplify that and just say there's the regulatory expectation, what is in the solicitation and the contracts, and then there's market pressure as well. So a lot of the large primes we're seeing push down expectations for level 2, sending letters to subcontractors down the supply chain to get level 2 compliant, to be working with a C3PAO, or at least get a self-assessment score of 110, because they want to make sure that their supply chain, their suppliers, can effectively support contracts that they're bidding on. So there is kind of that sweeping expectation, as you mentioned, Cy, around getting to level 2.
Yeah, and there actually have been false claim cases that, like I alluded to as well, that have already occurred about cybersecurity issues and compliance with NIST 800 standards, 171 in particular. I don't think there have been any 172 issues yet, but with 171, and folks claiming that they have it or that they're compliant. And so it's not just a matter, I think getting the third party assessment too is also not just a matter of just a compliance question or contract compliance question. It's also a broader compliance question too, to ensure that you've got some level of protection there, because I know the Department of Justice is really looking at any sort of fraud right now, especially in the small business space, not just programs or 8A or HubZone where there are known big investigations, but in all of these different areas. And folks have been found accountable for these sorts of things. The other thing I'll mention too is that I've heard folks trying to run things through different like AI models and things of that nature. And that also is something that in our discussions with the Department of Justice, they're actually looking at as reckless disregard for the truth if you're using large language models to give assessments of compliance on a number of levels. They're getting more aggressive at looking at that as also being potentially a fraudulent action, and that you're meeting that sort of what they call mens rea or scienter requirement, that you're recklessly disregarding the truth if you're not taking into account the potential errors in these models and things of that nature, or actually going into a deeper assessment if you're just sort of relying on those sorts of things too. So be careful with some of that stuff. And those are just a few of the latest and greatest issues that we've come across.
Yeah. And, so there are a couple questions that popped up about that bifurcation of level 2. I figured I would just go ahead and address that. We talked about the self-assessment versus the third-party assessment. So originally, when they bifurcated it, DoD indicated that at the time that most would probably need self-assessment versus third-party assessment. And then they sort of flipped that several months later and said most will probably require third-party assessment, and there will be a few that only require a self-assessment. Still the same framework, still NIST 800-171, and still requires an affirmation in SPRS. But that is correct. There technically is at level 2 a bifurcation. But to my point earlier, it's really important to be clear in understanding the solicitation and understanding your prime. If you're a sub, what your prime expectations are, because there is the regulatory and the market pressure. So certainly wouldn't encourage anybody to necessarily do something they didn't have to do, but I would definitely make sure that you understand what the expectation is for the contract that you're looking to be awarded. So now we've got the rollout timeline, which I did want to touch on, especially since we got the 48 CFR rule finalized last year in November. But essentially, there's a 4-phase rollout. You've probably heard of it was originally defined in the 32 CFR rule, and we were waiting for the 48 CFR rule, which would implement the CMMC program into solicitations. We're waiting to see when that would actually take effect. And so when we got the 48 CFR rule that went into effect November 10th of last year, it kicked off phase 1, which essentially continues the self-assessment permission across all level 2 requirements. So you don't have to have a C3PAO assessment right now if you're level 2, but it does essentially activate the CMMC program. We're starting to feel the bottleneck and starting to hear pressure, and a lot of impetus on getting compliant is November 10th of this year when phase 2 starts, which essentially states that self-assessments will not be required at level 2 where a C3PO is required. So essentially you'll need that assessment by November the 10th in order to be awarded a contract with the CMMC level 2 requirement in the solicitation where a C3PO assessment is required. There are waivers, there are options for DoD contracting officers to delay that requirement into phase 3, which is a year after that, so November 2027. So there is the possibility for that, but DOW in their FAQs, their frequently asked questions, basically stated that that's not something that contractors can request. It's not something that we expect to be very common. It's really at the discretion of the contracting officer. If it's going to put a performance of a particular need in a contract at risk. So I wouldn't count on that as something that you could potentially go and just request. And then at phase 2 here in November 2026, we'll also see those level 3 assessments start to be performed. Again, expected to be a little bit rarer. Larger primes are focused on that, special projects and programs, but those will begin. I know that DIBCAC and DCMA are piloting that right now with some of the larger primes. So we'll expect to see those definitely starting here later this year. I mentioned the November 10th, 2027 deadline, or the phase 3, I guess I should say, kickoff, when the extensions will actually expire. So if you're given that waiver starting this year, that lasts a year. And so in phase 3, those will need to be converted into third-party assessments. And then by phase 4, November 2028, they're calling that the full implementation of CMMC contracts, where we'll start to see new solicitations pretty much required across the board. And then there's a 7-year plan to, by the 7th year, every contractor will be CMMC compliant. That'll be probably 2030 or 2031 at that point. But we're here. It's official. We've been talking about it since 2020, and so now we've got the schedule and rollout. We're in the middle of it. So I don't know if you got any additional thought there, Cy, but we're moving forward.
Yeah, with OTA issues too, I know a lot of folks, 2 things, one with OTAs, one with protests. I get a lot of questions like, well, they're non-FAR based, so is this really something that is going to be required? And from what I've seen, especially with the OTAs that are really taking off, that our clients are working on, they are like higher level and more secretive or sensitive projects, and they already have these requirements essentially. And so they're definitely going to be full level 2 with third-party assessments, is what I've been told. And to the extent folks are thinking about potential protest issues, if the government were to put on like a level 2 that is requiring third party, I think it's very unlikely that would be a successful protest basis. You'd be claiming it's unduly restrictive of competition, but the reality is that a lot of these things are national security based, or that's going to be the claims. And GAO, or the Court of Federal Claims, is unlikely to overturn some of that. Maybe at the level 3 stage, you could have some sort of claims there. But again, if they're doing that, my understanding is that that's going to be based on really high level requirements. So if you're looking to work on especially things like AI driven work or counter drone work and intelligence areas, that might be a whole other thing. So you not only are going to have to get this level 2 third party almost as a guarantee, but maybe level 3 as well.
And so one slide that we put together was really around the applicability estimates, which DOW has attempted to give both within the 32 CFR rule, which established the program back in 2024, and then the 48 CFR rule, which was finalized last year, which again implements that program into solicitations. And essentially, one highlight, we don't compare it here on this slide, but the 48 CFR estimates are higher across the board than the 32 CFR requirements. And so if you look, you can look at each level, and DoD has attempted to estimate small entities versus large entities and at what level, percentages, and so forth. So they've kind of painted a picture of what they see, this will look like over the next 3 years during the rollout. But the level 2 certificate assessment total entities is 118,289 companies over the next several years. And so if you think about that bottleneck that I mentioned with just 100 C3PAOs right now that are authorized, hopefully that number grows. We're going to need more assessors. We're going to need more organizations conducting these assessments in order for this to be a successful program. But even then, if we grow by a couple hundred, it'll still be pretty tight over the next several years. So I would expect this bottleneck to continue. And would certainly encourage you, if you anticipate a need for a C3PO, to reach out to one as soon as possible. But the reason that, in my perspective, that these estimates in the 48 CFR rule are higher than the 32 CFR rule is because what we're finding when we start conducting these assessments is that the initial estimates were based upon organizations needing a certification as an organization. And so an assumption of one per organization. But the reality has come out with larger complex organizations, multiple business divisions, research entities and higher ed institutions often have program managed enclaves and different research environments that need different assessments, that there are actually multiple assessments per organization at various levels. And so they've attempted to sort of address that here in the estimates in the newer rule, the 48 CFR rule.
Yeah, that's an interesting point too, because I've had a lot of folks in the past, probably a year or so, that are looking to potentially bifurcate some of their commercial and federal work, or maybe more to the point, moving certain intellectual property and things of that nature into different entities, or maybe housing it in the commercial entity and then sort of a lease back. Well, it oftentimes, especially when you talk about IP issues, the government is going to want certain work done on that might have it be sort of specialized to what the government's looking for. And if you're doing that and you're sharing information or have to share data between different entities, then it's very possible that each entity is going to have to go through the process. And even though you might be separating it to do commercial work or something of that nature, it's not going to necessarily get you out of some of this. Now, it might if you're only doing purely commercial and you're not sharing data or information, but just be aware of that as well. And the other thing I think I'll note is just the raw numbers here. Yeah, as a percentage, more of the large entities might be required to have higher levels. But just from a pure number standpoint, just because there's a lot of small businesses out there, there's a lot of small businesses that are going to have to go through this process more than any other type of company. And that mirrors what SBA is seeing too and what they expect. So just be aware of that. And even if you're a subcontractor, right, you might be left out in the cold if you wait too long. It's almost like folks that tried to form joint ventures for STARS 3, for instance. That was one of the hot button ones where everybody was struggling to get things done, and then there were unexpected delays getting maybe an LLC through SAM or something like that, and they missed certain deadlines, and people tried to protest to delay the RFP responses and things like that, and most or all were unsuccessful in pushing for that. So just be aware, plan ahead, and there's a lot coming down the pipe that might not be on the same timeline as when things are going to be absolutely required by law. They might be required by the RFPs or RFQs out there. So be very aware.
So some other highlights from the 48 CFR rule, and this is really speaks to, most of them speak to the supply chain aspect of this framework, which we don't talk a lot about, or the flow down, I guess I should say, of the CMMC program. Um, this this is very flow down driven, so it is all the way down the DOW supply chain. And what they've essentially indicated with the 48 CFR rule is it is up to the primes to manage the CMMC compliance down their supply chain. DOW is not going to deal with subcontractors, as they don't with various other issues. But it's really important that the CMMC program be implemented in supply chain management for medium size and larger primes. Essentially, what the expectation is that primes maintain a list of their subcontractors and their compliance status with CMMC, and especially as it relates to the flow down of CUI, handling that controlled unclassified information. And there's a unique identifier called the CMMC UID, which is assigned to every single assessment that's conducted by a C3PAO, and that's input into the EMAS system that manages CMMC with DoD, and as well as a SPRS system. And essentially that has to be provided up the chain, and any changes to suppliers and their compliance status have to be managed and maintained by the prime and then reported to the contracting officer. You don't have to report, one of the newer things, which you don't have to report lapses of information security or any issues that come up. I mean, data breaches are different, but just lapses and changes in information security status. But you do have to maintain compliance and report any changes as it relates to compliance.
Yeah, and it's also, because it's your responsibility there too. This might also be in an area where you want to push back in different subcontracts if you're a prime, to make sure that when it comes to indemnification clauses and things of that nature, it's very common to see an indemnification clause that just says no special or consequential incidental damages are allowed for either party, and people sort of reflexively make that mutual because that's what people demand. You're like, okay, fine, who cares? Nothing's going to happen anywhere. There's a small percentage chance that anything would happen. But with something like this, I don't think it's unreasonable to have certain carve outs to that, because if they falsify information, the money that you could get from them, especially if they're very small, you might not even be able to get that much. But even if they are a wealthy company, and even if you are able to get that ultimately after going through litigation and everything else, even if everything works out that way, it might not be enough, because you're going to lose contracts, you're going to have bad CPARs, you're going to have all of that. And so to the extent that there are additional damages that you could tack on to things specific to these kinds of certifications, it's not unlike other very crucial certifications like small business and things of that nature. So just be aware of that as well as you're negotiating things.
Awesome. So I did want to cover here some of the assessment process, what it looks like. We get a lot of questions. There is the publicly available certification assessment process document, or CAP document, that's been published by the Cyber AB that all C3PAOs have to follow. Essentially, self-assessments have to follow something similar around the scoring methodology, but I just want to highlight some of this and bring some transparency to what the process looks like. But essentially, there are three outputs that are possible with an assessment. So using DoD's scoring methodology for conducting the assessment, you have to have a perfect score, essentially, to have the final certificate of status provided by the C3PAO. It lasts 3 years. There is an off-year affirmation requirement, which I think we'll dig into here in a little bit. But essentially, in years 2 and 3, you have to go reaffirm your own status without a C3PAO. But the maximum score is a 110 Oddly, there are 110 requirements, and so there's a scoring methodology behind it. But if you achieve that perfect score of 110, you get that final certificate of status, and that lasts again for 3 years. But there is the opportunity to potentially not meet all of the requirements during an assessment and still be able to get to that final certificate of status. And so if you get through an assessment and there are a couple of requirements that are eligible for what's called a plan of action and milestone process or POAM process, you can actually fix an issue or multiple issues after the assessment and then have the C3PAO come back in and complete a what's called a POAM closeout assessment to validate that those issues have been remediated and that you've essentially achieved a 110 score, a perfect 110 score, and then you'll get a final certificate of status at that point. If you do not have an 80% or you have a controller requirement that fails that is not eligible for a POAM, that automatically fails your assessment. And that's obviously somewhere you do not want to be because that restarts the entire process. You have to start the assessment over. Onboarding and intake with C3PAO and into EMAS during the initial stages of an assessment are fairly complex. And so that assessment would have to be closed out if the assessment fails during the assessment week, and then it would have to a new one would have to be registered with the C3PAO. So obviously failing as an assessment is not ideal, but it can also be fairly disruptive and hard to kick off a new assessment. And as far as what the risks are associated with not completing an assessment, primarily the major one is you could potentially lose out on work. So that's the impetus for CMMC at this point, is making sure that you're fully compliant. They typically are recorded. Failed assessments are recorded in EMAS because we have to close out the assessment. We do intake, so we have to close it out. It's just not a good look. I think it could be optics, if you want to call it that, from a marketing standpoint. It's not publicly available, but failing an assessment is just not a good look for an organization. So it's certainly not ideal.
Yeah, and that also goes to if you've made claims to compliance and you knew or should have known that you weren't compliant, and depending on if it's usually there's some sort of leak or something occurs, and then if they come in and look at it, that's just another place where they're just going to potentially throw the book at you. So just be aware of that as well.
So as far as assessment logistics are concerned, what are we seeing? We've talked a little bit about this, that the large primes are pushing this down sort of without, there being the requirement right now. They want to get ahead of it. They want to make sure their key providers are ready to be compliant as well. So there's that market pressure that we talked about. We also have already talked about the bottleneck of C3PAOs. It's really at the individual assessor level. So you can have 100 C3PAOs. That would be sufficient if you had enough individual assessors to conduct the assessments. But it's hard to earn what's called the CMMC Certified Assessor Credential or CCA credential, because not only are there multiple courses of training you have to take, there's an experience level requirement, there are exams, but then there's also a Tier 3 suitability determination handled by DCSA, which is a very light background check, but it still takes a while to get through in order to become a CCA that can participate on assessments. And each assessment, by rule, has to have 2 CCAs conducting the assessment, and then a third CCA performing a quality assurance check of the work that was performed by the CCA assessment team. And so that's at least 3 CCAs participatory. As you can imagine, that can cause a leverage challenge for some C3PAOs that may not have access to CCAs and can't. So as a result, they can't conduct as many assessments as they could otherwise, or certainly would like to. And then one thing I typically like to comment on is if you join the Cyber AB's town halls each month, they give a monthly town hall update on CMMC from their perspective. They have DoD representatives on occasionally as well, but they also give numbers of the assessments that have been completed, number that have been completed, along with the number of assessors that are now in the marketplace and C3POs and so forth. But the number of total assessments, how many were successful, how many failed, how many in progress, et cetera, you'll note that the majority of the assessments to this point have been successful. And I certainly is a good thing. But my perspective is that it's because there's a bit of an early mover, not advantage, but those that have wanted to be early movers have done the work to be prepared. They've wanted to be successful. They've paid attention to what they've needed to do. What I'm wary of heading into next year, after November the 10th, and in the coming years, we'll start to see some organizations that are kind of forced into this by their primes or by DoD contract, and may not have prepared as well, or may not have been as thoughtful about cybersecurity protection as they've needed to be. They race to get ready, whatever it is. We may start to see more failed assessments as we go along. And so that's back to the idea of now's the time. It certainly is appropriate to start thinking about this and making sure that A, you're prepared, and then B, you've got a C3PAO ready to go when you want to have your assessment conducted.
Yeah, and also if you previously stated to a prime contractor or directly to the government that you were compliant with, let's say, just the standard NIST 800 171, and then you get an assessment and you never were, that also, not to keep harping on the idea, but I've seen this happen. That's also a situation where you might have to make a mandatory disclosure either through the prime or directly to the government. And I've seen prime contractors that get very wary about that and are very worried about damages or reputational harm, things of that nature. So it can really hurt you if you're not getting prepared ahead of time. So just be very wary of that as well as things happen in the future.
Continuing on the assessment process real quick, I'm not going to get into the scoring methodology in depth. It's not overly complex, but essentially each requirement is given a weight or a score of 1, 3, or 5. The perfect score is 110, but if you do the math, just assumptive math, that if you fail a lot of the controls, you could potentially drop below a 0. So we often see negative scores as organizations are just getting ready to go through assessment. But so it is a weighted process. The heavier weights are 3 and 5. So those controls are certainly the focus. But we did talk about the 3 outcomes and where the conditional certificate of status, which is that temporary certificate, if you do fail certain requirements or not meet those requirements during the assessment, that you can potentially remediate those during a POAM closeout period. And I don't know if I mentioned that period is 6 months. So you have 6 months from the completion of the initial assessment to remediate those issues, to then have a C3PO come back in and validate the closeout.
And I think that also, depending on the requirements and the sensitivity, you could have contracting officers that are not so thrilled if there is some sort of failure or something like that, and might put pressure on you from a contractual side to move even faster than that. So just kind of be aware of that as well. And so you might have to keep your contracting officer in the loop, especially if there were to be some sort of breach or some issue because of a non-compliance piece.
And this is just a screenshot extracted from the rule itself, outlining what the weighting is and the maximum scores. So as I mentioned, the basic security requirements are the highest weight, 5 and 3. Derived security requirements are a little bit lower. The 1 score, for example, limited or indirect effect on security in the network of its data. Typically, those are the POAMable controls. And so we'll sometimes see those, cause a less than a 110 score, but again, that can be remediated.
Yeah.
So now let's talk about what it looks like in practice. So that's we talked about the scoring methodology, the process, but what does it actually look like? And this is really for the organizations out there that are considering assessment. We did talk about this certification lasting 3 years, but I want to comment that an efficient assessment is really dependent upon the organization's readiness to go through the assessment. And so having the documentation ready, being engaged with the C3PAO, having the right people, the stakeholders involved from the get-go is really critical. I would also say that this is an assessment of process more than it is an audit. So your documentation is critical. It's not a gotcha exercise to try and capture, well, back on, 6 months ago, there was, a failed control. And so we're going to completely fail the assessment. That's really not how this works. It is a look at your process, the way that you define how you meet the NIST 80171 framework at level 2, and then just working with you, the C3PO works with you to validate that that's in place and in process. It is a point in time assessment. We do like to see some evidence of, operational implementation of controls over time to make sure that it is operating, but it's not a, period audit, like if you might think of a SOC report, something like that, a period audit. So we'll just walk through. It's very observation heavy, walkthrough heavy, show us how a particular control works, pull up this screen, this dashboard and system, et cetera. So that's typically the way the assessment goes. And then there is a requirement for artifact hashing, which I think we'll talk about here in just a minute. But essentially, that is retaining all of the evidence that a C3PAO takes a look at during the assessment process. You have to retain that and then hash that through a hashing algorithm, which outputs a string of data that can be used for non-repudiation later in the event of a incident or a false claims act. We can go back and validate that the evidence we looked at, you have captured that and retained it in its original form and can be used for a review during any sort of litigation or investigation.
Yeah, which again goes back to some of the importance that we've been talking about of also actually doing these things, because I know in a whole host of other scenarios too, where folks are looking for, either a template for, a particular policy, or they input some sort of policy that, might be a little expensive and they do it for a period of time and they fall out of compliance. Like once you have all these things in place, and not just from the technical side, but from the policy side too, you got to make sure you're keeping up on all these things, because if anything occurs and you've fallen out of compliance, the DOJ is absolutely going to look at these things as being purposeful, even if it was just a sloppy mistake or sort of reckless disregard for the truth, things of that nature. So again, be very careful with some of this stuff.
Awesome. And back to the sort of assessment process that I started to describe there, what C3POs and the assessors are doing. The assessment is typically conducted in an assessment week. And so it can be 3 to 5 days, but we group the walkthroughs and validation meetings by control family, by requirement family, access control, incident response, risk assessment, risk management, and so forth, to make sure that we're speaking with the right control owners. But there are essentially 3 ways, as defined in the assessment guide, that we can validate implementation, and assessors have discretion on how this is performed. But examine, interview, and test. Essentially, we can take a look at, show us how something is operating, or interview. We can walk through a particular process with a control owner and talk about it and just validate that they're doing what the policy says you are doing. And then testing, which is actually, putting a particular control through a test. So, for example, changing, making sure there's no default passwords. We might ask you to put in a default password into a particular system. We validate that the default password isn't active and isn't working. So just note that assessors have discretion. Different C3POs, different assessors like to take different approaches, but and certain controls may be looked at in different depth than others.
And who do you guys usually talk to? Is it sort of the IT department? Is it the ownership structure? Like, who do you guys usually work with or try to talk to if you're going through some of these processes and confirming things?
It's typically the IT department. I mean, we're looking at a lot of IT controls as part of this, and cybersecurity controls. Sometimes managed service providers come into play, so they'll be participatory, either walking alongside the organization or actually operating the control on behalf of the contractor.
Yeah, which I guess is also another point that should be made if you're using a third party, not just from the perspective of a managed service provider who might be doing all of your back office or all of your IT back end, I should say, but in individual maybe programs or environments that you might be using. There's also a piece there that you shouldn't just rely upon representations. You're going to have to make sure that you do some sort of review and assessment of the various programs or vendors, things of that nature that you're actually using for things. If you're holding information outside of your own personal networks, so just be aware of those things as well, that whenever you're making representations not just about yourself but about everything that you're using and everywhere where you might be storing this information that is covered. So it's just another piece of the puzzle that you have to pay attention to.
And just I mentioned briefly that documentation is key. So it's the assessment typically starts with what's called a readiness review, where we take a look at the sufficiency of your documentation and readiness to actually undergo the assessment. And so that we ask for the system security plan, which is the crux core document of any CUI protection program, any supporting policies and procedures, operational documentation, your network diagram, data flow diagrams. We basically just try and validate understanding of the scope and readiness to undergo the assessment. And so I include this slide just to highlight the importance of documentation readiness right up front, because we're going to ask for a lot of that. And if it's insufficient, um, it could potentially delay the assessment, or we may not want to continue the assessment for risk of it potentially failing.
Yeah, and the system security plan is one of those items that I was kind of referring to before, sort of like OCI mitigation plans and things of that nature, where folks just are looking for a template. I get these questions all the time. Is there a template for this? Or you go online and you try to find something, and you're like, okay, well, now we have it in our file, in our folder, and we can supply it as part of a RFQ, RFP response, whatever it happens to be. And if you're doing that, that is probably one of the most risky things you can possibly do, because then you're making a representation that you are doing every single thing in there, and you might not even understand what you're looking at, right? You just kind of pulled it, or you had it put together, or even maybe even worse, if you had like an AI thing, trying to throw something together and you're representing to the government or to a third party that you are doing everything in here, and you don't even understand what's in it. Um, or it's might be things that you can't even physically do. I've had that come up as well, and that is just such clear evidence of a false claim that the Department of Defense, the Department of Justice, when they're looking at things, they are really going to look at that very harshly, and it's going to be extremely difficult to convince them otherwise, because you weren't even paying attention, like the basic level of attention on doing that. So it'd be extremely careful and be aware that these are things that are supposed to be tailored to your company and what you can actually do and what you are actually doing, not just what you could be doing. And all of that is critical.
So we've got about 10 minutes left, it looks like, but we'll kind of truck through now what it looks like after the assessment. Essentially, if you've got the 110, once you get there, there's an initial closeout call. And so but that kicks off a process within the C3PAO to finish compiling the notes and make sure everything's organized. And then the QA process starts. Assuming everything looks good there will be a final closeout. where the C3PO will affirm, the lead CCA will affirm that the 110 score is accurate, and everything will get uploaded into EMAS. The certificate will be provided to you, to EMAS, to DoD through their EMAS program. I think that kind of covers completes the assessment process, and then that PDF certificate is signed by the lead assessor or a representative of the C3PAO, and given to you, and you can use that up the chain, up your supply chain with your primes. Quick touch on POAM closeout assessment. We did talk about these a little bit, but essentially it is a completely different assessment technically in EMAS, so that has to be reported in separately in EMAS. You can have another C3PAO do it. I would not recommend that. Frankly, I don't think C3PAOs would want to do a POAM closeout assessment if they didn't conduct the actual initial assessment, but it again has to be done within 180 days, and there is the minimum score requirement. So different than the previous DFARS 7012 clause that permitted virtually any POAMs, there is a limitation around it. I think that's the important point to take away, is that you have to have the minimum score, and only certain controls can be eligible for POAM closeouts. Let's jump ahead, Cy. I think we talked a little bit about artifact hashing. We don't really need to talk about the artifact hashing, maybe except to say artifacts have to be kept by the OSC themselves for 7 years, along with the hash, which the C3PO will also keep, and it will be up in EMAS. So it is important to make sure that that's part of your process during the assessment, and your C3PO should advise you of that during the initial meetings and the closeouts. But essentially, what's important after the assessment? So we're all racing to get to, assuming a level 2, getting that certificate of status or the 110 score. But what comes after that? Because it is a 3-year certification life cycle. There is the potential for a lot to happen in that 3 years. I did mention the annual affirmations by an affirming official inside of the contractor organization has to be done within SPRS every year on your assessment anniversary date. But business changes throughout the year, and there are mergers and acquisitions, significant IT transformations, things that potentially impact the boundary and scope of your previous C3PAO assessment or your previous CMMC certification assessment. And so it's important to monitor that, because significant changes by the 32 CFR rule do require a reassessment. Now, very ambiguous. What is a significant change? That's a huge question right now across our industry. C3PAOs, are not able to necessarily advise on that, but the C3PAO Advisory Council is trying to compile what we see in the industry as we conduct assessments and offer our perspective and recommendation to the Cyber AB and DoD on potentially defining that a little bit better. But essentially, anything that would change the boundary, any new cloud service provider, new facilities with new systems, that very often can trigger the need for a reassessment. Maintaining the business as usual controls, as we call them, BAU operations, that's going to be important. We're racing to get compliant. We put these controls in place. It's really important to continue to operate them even after we complete the assessment, because as I mentioned earlier, the next time you get an assessment, C3PAOs could potentially want to see operation of that control over time. And so you obviously want to protect that information, but you also want to maintain a compliant status even after your certification assessment. Do not forget to the annual affirmation requirement. That is a requirement to continue to be compliant. And then revision 3 of NIST 800-171. We haven't gotten into that, but essentially we are on revision 2 right now of 800-171 as it relates to CMMC. So your C3PAO will look at revision 2 of NIST 800-171, those 110 requirements, but there is a newer version of that framework with additional controls, additional requirements that is coming. And so at some point by change in rulemaking, we will see revision 3 integrated. And so it's important to start to think about that now as you get through your Rev 2 assessment, it's important to start thinking about the Rev 3 compliance framework as well. Just reaffirming the affirmation process. Essentially, it's required at all levels, levels 1, 2, and 3. But it's important to note that even with your C3PAO assessment, after they are completed, they have input everything into EMAS. That gets batch updated into SPRS. And after their assessment, the affirming official inside of the contractor has to go in and conduct the affirmation, even with a C3PO assessor, in order to be considered fully complete with the assessment and fully compliant. So do keep that in mind as you work with a C3PO, that you have to do an affirmation as well. We can go to the next slide. Yeah. So what to do in years 2 and 3? We did talk a little bit about this, supporting the affirmation process. Continue to think about the BAUs, the mergers and acquisitions. If you change that scope, if you add new users by way of acquisition, merge systems, and so forth, that would typically trigger a reassessment requirement. Updates to the system security plan, make sure those are conducted when you add new tools, change tools. Make sure that your system security plan is a living document and is updated, because you don't want to get to your next assessment and have your system security plan be completely inaccurate and out of date when the assessment begins and the C3PAO can't follow or can't validate anything. That would cause a big issue during an assessment.
Yeah, and if you're using third parties, make sure they're going to report to you as well. Like that, if they're making changes on their back end, things that could impact you, all of that's going to be also important to pass along.
Absolutely. I think we talked just about all of these. The only other thing I would say is some organizations like to use a C3PAO even in the off years when they're not required to conduct essentially a mock certification assessment, or just an assessment against NIST 80171, scoring it but not providing recommendations, essentially maintaining independence, but also giving you all a level of comfort as organizations that you're still doing what you need to do from a third-party perspective, from an independent perspective. So keep that in mind as well as a potential option. But Si, I'll turn it back over to you for questions or closeout.
Yeah, and so I think to the extent that folks have any issues or things that they want brought up with SBA, there might be some stuff in here. Let's see. How does it work for small businesses with an FCL and DD220? Let me see if I can see the full thing here. If you hold CUI or not, is there anything we need to prepare for differently if there's an FCL? I think if you have a DD254 but you don't have any CUI and you're just doing but you have confidential information or classified information of any kind, not just confidential, obviously secret, top secret. That is stuff that it's like a whole nother level, right? You should already have various controls and various things in there as well. But I don't know if you have things to add to that issue.
No, that's a little outside of my area of expertise.
Let's see. I know we have a number of certain questions here. What sort of language of the contracting officer solicitation use specify if there's third-party certification required? Is it just the inclusion of 80171 or something else? I'm trying to think if I've seen specific language. It should say that you need the third-party certification, but is there anything specific that you've seen?
It'll reference the CMMC clause. What sort of language? Excuse me. Contracting officer solicitation used to. It'll effectively outline what the requisite level is for CMMC. So it'll reference the CMMC clause and requisite level for meeting that compliance obligation. It won't say NIST 80171 specifically.
How about this is an interesting one of the questions about whether it's the prime contractor's responsibility to notify the contracting officer when there's a third tier subcontractor and their UID expires. Have you that I have not come
I haven't
across
seen
yet.
that just yet. I mean, we haven't seen really UIDs expire to this
Mhm.
point because most of the assessments done early were JSVAs, which are just now probably starting to expire. Can't say I've seen that scenario yet, but we'll start to get some case studies around it for sure.
And as far as DoD treating small businesses any differently than large prime contractors, yeah, that I haven't seen anything, and to the extent that the data you're talking about is of whatever level that the contracting officer believes needs to be protected, that's going to drive it much more than the work that you're doing. Now, to the extent that I think that if they do market research and they find that really what they need is, let's say, a level three, right? Then that is going to be a factor, and you might not even see that come out as a small business set aside to begin with. Like that I think is more of where you're going to see discrimination happening as opposed to reducing the need, because it's all going to be driven by the data.
Yeah, it's driven by the data, and frankly, we get a lot of questions about the burden of CMMC, which is legitimate. I mean, there is cost to it. There is effort that's required. Katie Arrington, when she was running the program, was very fond of saying this has been a requirement. NIST 8171 has been a requirement since 2017, since the original DFARS rule. Now we're just validating it. CMMC is really designed to scale. It should scale. Right now, we're very early, so there are a lot of questions that have to be answered. There's a lot of burden that we could potentially reduce via various solutions. And then there are some providers out there that might be taking advantage of the situation from a pricing perspective, that there's such high demand for it. So I think the market will equalize here a little bit. We will find ways to make this easier on small businesses, but this was designed for small businesses. That's where the breaches were happening, is down the supply chain, more so than at DoD or with large primes. So relief, I think, is coming, but it will take the entire market working together to make that happen.
Yeah, and that's one of the things that I talked to SBA about, and I think we're going to be talking about tomorrow as well. Is potentially how do we build this into certain costs, maybe directly, things of that nature. But it's hard to make it direct costs because this is going to be a broader issue, and so one contracting officer, one agency, kind of paying for this when it's going to be needed likely throughout the entire government and not too long in pretty short order. I think you're going to see some pushback on that as well. So kind of stay tuned for some of those issues, and I guess we'll see where things go. But yeah, so we're gonna post this stuff. Obviously, if there's some questions here we can dive into. I know we're out of time, and Tom or maybe we'll get back to folks. And as I get more information too, like I said, with some of this SBA stuff, I think we're going to keep people updated, and I'm sure we'll do more as we get further and further down the line on this. So thanks again, Tom, for coming. Thanks, everybody. And we will be back and we'll follow up with other folks, like I said.
Sounds good. Thanks again. Appreciate it, Si.
Yeah, thanks.